Okay, hi everyone. Sorry for the delay. We were just trying to overcome a little technical hitch, but I think we're ready to go. Welcome to PNP Live. I'm Brad Graham, the co-owner of Politics and Prose, along with my wife, Lise Muscatine, and we have a very revealing program for you this evening featuring journalist Lise Olsen and her new book, Code of Silence: Sexual Conduct by Federal Judges, the Secret System That Protects Them, and the Women Who Blew the Whistle. A couple of brief housekeeping notes first, though. To post a question at any point during the discussion, just click on the Q&A icon at the bottom of the screen. And in the chat column, you'll find a link for purchasing copies of Code of Silence. Lise is an investigative journalist who's been based in Texas for a number of years. Her reporting is focused on crime, corruption, worker safety, and human rights. And her work has appeared in the Houston Chronicle, the Texas Observer, and other publications, as well as in documentaries on CNN and A&E. It was her extensive coverage of federal judicial corruption, including an initially secret sexual assault complaint and subsequent impeachment of a federal judge, as well as other misconduct cases, that led Lise to write Code of Silence. She focuses in the book on the very disturbing case in Texas of U.S. District Judge Samuel Cant, who was the first judge impeached by the House of Representatives for sexual misconduct, and one of only 15 federal judges to be impeached in more than 200 years. Lise also weaves into her informative narrative instances of misconduct by other federal judges who are appointed for life and can be removed only by Congress. And she explores the flaws in an oversight system that all too often fails to hold errant federal judges sufficiently accountable. Publishers Weekly called Code of Silence an enraging and eye-opening account of corruption and abuse within the halls of justice. And yes, thanks to Lise, we do have signed copies. In conversation with Lise this evening will be Carrie Johnson, who's also a journalist with a lot of experience covering justice issues, law enforcement, and judicial affairs. She's currently a justice correspondent with National Public Radio, where she's been for 11 years. For a decade before that, she worked at the Washington Post, reporting on the FBI, the Justice Department, and criminal trials. Still earlier in her career, she wrote about courts for the weekly publication Legal Times. So Lise and Carrie, the screen is yours.
Thanks, Brad. Lise, it's so great to be in conversation with you about your book. And I must say, I did, as Publishers Weekly said, find it enraging on so many levels, but also inspiring because you really dug up some important information here. I'm hoping you can set the scene for the conversation by reading just a short passage from the start of Code of Silence.
As Brad so graciously said in a wonderful introduction, and thank you to Politics and Prose for inviting me for this reading. I'm an investigative reporter in Texas, and in that course of my time there, I've heard some very odd tales. I've heard about a 17-year-old who was falsely accused of capital murder and executed. I've heard about a crooked congressman from Texas who was using his employees to steal, but no story matches the story that I heard about a U.S. district judge who literally was sexually assaulting employees in the federal courthouse. And so I'm going to set the scene by reading from the very beginning of this book. And this is the prologue the section called The Tip. And pardon my wobbly camera, this is my cell phone I'm talking to you from. So very personal up to tonight as we speak together. Houston is a humid, heavy breathing city where news takes no break, even when quitting time approaches on a Friday. I was absorbed in notes for another investigative story in our bustling Houston Chronicle newsroom in March 2007, when Deputy Managing Editor George Hodge waved me into his private office and shared one of the most improbable tips I'd ever heard. Hodge told me that Harvey Rice, another senior staff reporter, had just called with a tale of something strange that a source had witnessed inside the federal courthouse on Galveston Island. That afternoon, a woman had run, crying, from the chambers of U.S. District Judge Samuel Bristow Kent, with her clothing in disarray. The tipster identified her as the judge's top assistant, Cathy McBroom, known as a normally unflappable court employee and Judge Kent's longtime case manager. After leaving chambers, McBroom never returned to her own office. Instead, she detoured to another floor, apparently to hide from the judge. Some co-workers believed Kent had sexually assaulted her. Perhaps if I'd worked elsewhere, I might automatically have rejected that rumor that a man sworn to uphold our laws would violate them in a so-called palace of justice. But I was an investigative reporter in Texas, the place where the improbable often occurs. Houston is, after all, the home to the moon men of NASA, home to Joanne Herring, the glittering socialite and heiress who allied with the Texas congressman to finance a secret CIA war in Afghanistan. Skyscrapers near our downtown newsroom had formerly hosted the swaggering swindler kings of Enron. Carrie, you covered that story, before their pipeline empire fell to fraud. So focused on the story, I navigated back through our metal cabinets loaded with newspapers, maps, and dictionaries, and plopped down at my desk, kept my voice low when I called Rice to follow up. It was such a sensitive tip that I didn't even want our colleagues to overhear. Harvey had lived on Galveston Island and was well connected there and in the federal courts. Before coming to Texas, he had worked for the Clarion Ledger in Mississippi. And during his time in Jackson, he'd been assigned to investigate rumors involving another powerful federal judge named Walter Nixon, no relation to the president. Nixon, rumor had it, had quietly accepted a bribe to help a business associate's son beat drug charges. Rice tracked down sources and ferreted out documents. Nixon ultimately beat the rap for bribery, but was convicted of perjury for lying to investigators and went to prison. Then he refused to resign and continued to collect his judicial pay as a prisoner. Rice had just alerted me to the unusual level of power we were confronting. Federal circuit and district judges, as you know, such as Kent and Nixon, are appointed for life under Article 3 of the Constitution. They cannot be removed from office for anything less than impeachment by the U.S. House of Representatives and removal by the Senate. Nixon was one of 3 judges who had been impeached and removed in the 80s, but no other federal judge had been impeached or removed since. Even if Kent had sexually assaulted an employee, I wondered how could we possibly confirm that? It was a classic he said, she said situation. Kent certainly wasn't going to talk, and McBroom seemed to have vanished.
Wow. So that's a Texas-sized story for you right there. You know, your book is a really deep portrait of women experiencing and by the end starting to recover from some of this trauma they experienced at the hands of this very powerful lifetime tenured federal judge. How did you find these people? How did you approach them and try to build trust to break down that code of silence that's permeated federal courts for so many decades now?
Well, at the beginning, especially in the Cathy McBroom case, no one would talk to me at all because the federal judges were secretly investigating the complaint she had eventually filed against Judge Kent. And they had told everyone else not to talk. So it took months before I could actually write a story. I spent a lot of time talking to lawyers first who practice in Kent's court. And then, and what was kind of appalling about that is they told me these long stories about abuse of power, that this was a man who was really out of control, who literally called himself King Kent, who was known to fine people thousands of dollars for showing up late. But at the same time, and so a lot of these lawyers I was talking to believed that Kent was capable of doing something like assaulting a clerk or an employee. And ultimately, I tracked down some former employees of the court, women who were willing to tell me on the record that they, in fact, had been sexually harassed or assaulted. But I still had this brick wall where no one could talk to me about what had happened to Cathy McBroom. And it was very, very difficult. I ultimately broke the story through a series of kind of tricky maneuvers that we can talk about a little later if you wanted.
Sure. And what about this? You've been an award-winning reporter for a long time now. What about this story prompted you to dig so deeply and to carry it this far, to make it the subject of what is, I think, your first book?
It is my first book. What happened was, when I heard the judges were investigating, I initially thought, oh, well, the judges, surely if this federal judge sexually assaulted his employee, will find out, will turn this over to the FBI or someone, and justice will be done, And instead, what happened is the judges issued a reprimand after several months of investigating, a totally secret investigation. And the reprimand said literally very little about what the judge had done. And it also said, we're not going to tell you what he did, essentially. We're not going to tell you the details ever. And as an investigative reporter, the last thing you want to do is tell somebody, I'm not going to tell you ever. I mean, that's like the red light, right? That's the red flag. And so what I did was I ended up, investigating further and deeper. And I ended up, I guess, getting very interested in the secret system of judicial investigations, and the fact that there were actually other complaints that had been made by women all over the country that also had not been fully investigated, and were also in some cases covered up, or women were told, that they shouldn't complain because nothing would happen. Or in the case of Cathy McBroom, they were told, they weren't even aware originally that the system existed. There's a system where judges investigate each other that's created by 1980s law. And so, what had happened in the Cant case, as appalling as it was, I realized it wasn't the only time it had happened. So I thought, this is a story everyone needs to know about. It's a cautionary tale to show what happens if one judge is allowed to go too far, because Kent, in fact, had been sexually assaulting Cathy McBroom, and he sexually assaulted other employees too. In fact, the investigation later turned up multiple women who'd been assaulted by Kent.
None of whom felt able to speak out, or, as you point out in the book, and just now, they worked for the federal court system and were not aware of any process to report wrongdoing within the court system. It kind of boggles the mind.
It does. And most people know that the federal judges are the ones who hear sexual harassment cases in other workplaces nationwide, but those laws do not apply to the judiciary. Judges generally don't go to EEOC training, that their employees cannot call with the EEOC with a complaint. They're not subject to those laws. And someone like Cathy McBroom, she'd gone through some of that training, but she had no idea that was the case. And she had never heard, she worked for the courts for 10 years. She'd never heard that there was a judicial disciplinary or complaint procedure. This law that existed since 1980 was not in 2007 on the website of the courts or the Fifth Circuit, even though it should have been, or if it was buried so deep that even an employee like her had no idea it existed. She had to be told about it by another judge. And when she was told about it, she was initially very afraid. She thought, well, is this just a way to get rid of me, to retaliate against me and make me a scapegoat? Am I going to pay? This is the way she was hoping to pay for her kids' college education and her own retirement. This was her career. And she was being asked to put everything on the line in order to report a complaint about a judge who had sexually assaulted her not once, but twice.
A total abuse of power. And when you got to digging, when you really got your teeth into this, what did you find out about the judge's investigation of Judge Cant? How fulsome was it? And what did you dig up there?
Well, so when I was working on this case, of course, early on, I did write a story that revealed that Cathy had been sexually assaulted twice. I talked to her mother and her best friend, who had heard that story from her directly. So I broke a story about that. And in response to that, members of the House Judiciary Committee issued a press release where they said that there should be a criminal investigation and the Fifth Circuit should reconsider its decision to simply reprimand Kent, which had the effect of giving him a paid vacation. He was allowed to take time off. He had no duties, and he was going to come back in just a couple of months and return to the same courthouse where Cathy was working. And so what I found out, not at the time, but later in the course of reporting this book, was that the investigation that was done over the summer by the judges was, I would say, far short of a model investigation in many ways. And I want to read you a passage about it, but just a little bit of a background first is these complaints come in and they go to the chief circuit judge all around the country. Our courts are divided into circuits. And so the Fifth Circuit, the one that's over Texas, is based in New Orleans. And the chief judge at the time happened to be a woman named Edith Jones. So every 7 years, the chief judge rotates in the circuit. And the chief judges, they have lots of other things to do. This disciplinary duty is sort of a side job for which they get no training. They get no additional funding. And in the case of Judge Jones, she had herself no personal experience investigating sexual harassment. She had no experience investigating criminal cases. She's a fine, intelligent woman, very intelligent woman, but she's in fact very skeptical of her sexual harassment cases as a jurist. In fact, at one point in her time on the bench, she had said to a litigant, to a lawyer in a case that was a case ultimately that her colleagues ruled was sexual harassment. Jones said, well, your client wasn't raped, was she? That seemed to be her standard. Then unless it was all out rape, it wasn't really important. So when she investigated this complaint from Cathy McBroom, she did what all judges do when they do investigate, which is they set up a committee of judges to investigate, and then they hire someone to help them. And in this case, she hired someone to help her who really also knew very little about sexual harassment or criminal cases. He was a fine insurance attorney, someone's very respected in Louisiana, but this was not his wheelhouse. So I want to set up for you what happens that summer when the judges begin to investigate. And also say that when Cathy filed a complaint, she revealed that she thought there had been 2 victims at least, that she thought that the judge's secretary, Donna Wilkerson, was also a victim. So in July 2007, the judges on the Judicial Investigatory Committee and their attorney arrived in Galveston to question Donna Wilkerson, the judge's secretary, first, in person and under oath in a closed hearing. Wilkerson knew many lawyers, but asked no one for advice before facing the investigatory panel in a conference room at a beachfront hotel. Its members asked her directly about Kent's behavior and about McBroom's allegations. Her inquisitors included Edith Jones, the formidable chief judge of the Fifth Circuit, and 2 other judges. Wilkerson later recalled, though no whoops. Brian?
What?
Oh, sorry.
It's me.
What
Can I do?
Can you help with this? I'm sorry. Something's going on with the Zoom.
Okay.
Anyway, I'm sorry. Go back. I'm back. Under questioning, Kent's loyal secretary stuck to a pared down version of events. She acknowledged the judge kissed and hugged her a couple of times. The contact was unwanted. The witness statement remained secret, but Wilkerson later recalled saying, yes, he was inappropriate with me, but it stopped. I handled it. Her statement hid the full truth. Though Kent did stop his advances off and on, Wilkerson much later admitted to federal criminal investigators that Kent had intermittently propositioned and groped her on days he'd been drinking over a period of 5 years. Sometimes he came up behind her chair and grabbed her breasts. Other times he pressed her into a hug and grabbed her bottom. There had been episodes of full-on sexual assault she did not mention to the judges in July 2007. But the investigatory committee members had not pressed her for details of his inappropriate behavior and did not seem all that interested in his behavior toward her, she thought. Instead, they wanted to know all about Cathy McBroom. How did she act at work in Galveston? How did she dress? Was she a flirt? Though Wilkerson supported her judge, she found their questions odd. Later, Wilkerson wondered why no one had asked whether Kent, her boss, had pressured her not to testify or whether she'd like a transfer. No one ever came to my rescue, she said. No one ever asked, do you want to be reassigned? That month, some of the same committee members traveled to the Hyatt Hotel in downtown Houston to question McBroom. McBroom arrived with her husband, Rex, who'd taken a day off to accompany her. Nervous and unsure about what to expect, the pair rode an elevator encased in the hotel's glass atrium and found their way to a small conference room. Minutes later, 2 judges entered through another door. U.S. Circuit Judge, I'm going to skip something here. Johnson, their attorney, took the lead in questioning. A senior partner with his firm, he'd handled depositions and arguments in hundreds of civil cases, but generally specialized in insurance. Jones' decision to hire a chief judge to hire an attorney who lacked specialized training in sexual harassment or sexual assault still stuns Lynn Hecht-Sheffron, attorney who for decades has trained federal and state judges on how to tackle gender bias. That is so far wide of the mark of how that investigation should have been conducted, she said. It's safe to say there were other firms who could have investigated it. In their secret hotel hearing, Johnson and the judges inquired directly about McBroom's professional and personal relationship with Cant. They wanted her to describe the outfit she wore to work and to exercise, were her clothes revealing. They asked whether she dated other court employees and whether she cheated on her husband. They wanted to know about outings to happy hours at local clubs and restaurants. McBroom was perplexed by the investigators' seeming obsession with her wardrobe. On the day she'd been attacked, she remembered wearing a pair of pinstripe pants and a blue sweater with a back cardigan over the top. She'd also been carrying a pile of court papers. What did that have to do with anything? When members of the panel got around to asking about details of the March 2007 attack, which McBroom had already described in her testimony in her written complaint, they asked McBroom and her husband to stand and provide a demonstration. They wanted McBroom to guide her husband so that he could physically reenact the way Cant had grabbed and groped her. Rex McBroom had heard all those sort of details directly from his wife, but being asked to perform a kind of play in which he depicted the judge he hated was horribly awkward and emotionally painful. Though Rex had accompanied his wife and continued to support her, the McBrooms were living apart, and now they felt they were being compelled to recreate the event whose trauma had strained their relationship to the extent that both feared their marriage would not survive. Rex was so reserved that communication had been an issue in their marriage. He wanted Cant held accountable, but disliked feeling forced to perform before such an audience. He thought judges overseeing the probe had assumed a self-protective posture. It seemed like a secret society, he said. They were trying to interrogate her to protect their secret society.
Devastating. And when I hear you read that, it brings up for me in my mind, some recent testimony before Congress by some world-class gymnasts who talked about the insensitivity with which they were treated by the FBI when the FBI was investigating sexual assault by a doctor tied to the gymnastics movement here in the US. To you, does this just more than tone deafness by these investigators speak to something about how we as a country deal with sexual assault? And to what extent do you think things may have changed, if at all, since the onset of the Me Too movement?
I think one of the reasons I wrote this book is I don't think the system and the country has changed enough since Cant was impeached for sexual assault. I think his case was forgotten. The lessons that should have been learned then were not learned. And history really seemed to repeat itself in 2017 when no less than 15 different women came forward in December of 2017 with stories about misconduct by a very powerful chief circuit judge named Alex Kaczynski, who was the chief of what is the largest circuit court in the country. The Fifth Circuit is the second largest, Ninth is the largest. And he was and it still is, I think, very well known nationwide. The allegations against him spanned his entire judicial career. They began with a woman who had been a judge with him in the 80s, who described how he groped her in a car, grabbing both of her breasts. And they included a very, very sad story about a couple of law clerks of his who said, especially one named Hattie Bond, who described how she felt like a prey animal during an entire year of a clerkship in which, for among other things, he privately showed her images that were explicit, nudes, and I guess he considered jokes, but she certainly didn't. And at the end of the day, what happened there was, this system we've talked about, this secret system where judges judge each other. It has a loophole, there's lots of loopholes, really. I mean, like we've talked about, chief judges have a lot of latitude about whether they investigate or not. But they also will drop investigations if a judge resigns or retires. So, for example, that's what happened in the Kaczynski case. All these allegations came forward, and just in a few days, Judge Kaczynski announced he was going to retire. And so the judiciary said, well, we're just not going to investigate. And that's okay under the law. The law says this system, the secret system, applies only to active district and circuit judges. And a year later, when Brett Kavanaugh, Judge Kaczynski's mentee, his former clerk, was nominated to be on the Supreme Court, obviously a lot of people watched Christine Blasey Ford testify about how she believed he had tried to sexually assault her as a teenager, and his responses. Those responses in the testimony generated the most known number of judicial misconduct complaints that have ever been seen. There were more than 80 complaints filed against Judge Kavanaugh, who at the time was a DC circuit judge, somebody subject to this system. But what happened in that case, just like in the Kaczynski case, is those complaints were never investigated not because he resigned, but because he became a Supreme Court justice. And the Supreme Court is also not subject to the same system. Now, I would say that, most people know the Kavanaugh story, but I think a lot of people don't know that there were that many complaints filed against him. And that, in fact, the courts themselves said that those complaints were serious in nature, and they spanned a lot of different topics. There was an unusual amount of information shared about those complaints. But at the end of the day, absolutely none of them were investigated, because not only does the system not apply to the Supreme Court justices, but it also simply ends. I mean, no one gets to find out anything. There's no post action report. There's no inspector general for the courts. And so we do know that because of what happened in the Kaczynski case, Chief Justice Roberts has appointed a group of judges to try to look at the system and figure out ways to improve it. But notably, he didn't include anyone in that group who had protested against Alex Kaczynski. And there were a lot of people who were very upset about what happened in the Kaczynski case. There were 800 people who signed a letter asking the courts to make changes. There still is a group called Law Clerks for Workplace Accountability, former law clerks, people who had worked for a year or more. And those folks were calling for change. And there was one change that about, which is that I think partly because of Heidi Bond's experience, the judges decided to rewrite a clerk's handbook to make it clear that clerks could complain if they were sexually harassed by their judges. But I want to read to you just a little bit from Heidi's experience to let you know how difficult it was, especially for a law clerk or any judicial employee to complain. And we're talking about employees who swear oaths and who are subject to codes of conduct. And in Heidi's case, she actually, in 2017, before she went public about what she'd experienced, she went to a federal judge and she asked, does my oath keep me from ever saying anything about the year I spent with Judge Kaczynski? And he told her, I can't answer that question. So she couldn't even get an answer from a judge about whether she was allowed to speak about what had happened to her. So I want to read to you a little bit about what's a whole chapter really about Heidi's experience as a clerk, which she described in great detail, both to me and also in an online blog entry that she wrote, because she's quite a gifted writer. She's an author. So she was really excited to get this clerkship because Alex Kaczynski was not only a chief circuit judge, but he was also what you call a feeder judge. His clerks often went on to work for the Supreme Court. So this was the opportunity of a lifetime for a young law clerk or young lawyer who wanted to be potentially a law professor or a judge someday. The world of the federal courts that Heidi Bond entered in May 2006 was and remains highly stratified, with judges at the top of the heap and clerks and other federal employees far below. Law clerks, handpicked by the judges for whom they will work, enjoy symbiotic relationships with those jurists. Part of the ritualistic federal court culture and the close clerk-judge relationship involves keeping secrets, both to protect the dignity of the judiciary and to safeguard the confidentiality of the process. But when Bond just arrived in Kaczynski's chambers, a suite of offices where her own space was located closest to his, she took that required oath to uphold the code of conduct for judicial employees, and she also received a copy of the thick handbook for law clerks to federal judges, which spelled out the rules. At that time, the handbook said, the relationship between judge and law clerk is essentially a confidential one. A law clerk should abstain from public comment about a pending or impending proceeding in the court in which the law clerk serves. A law clerk should never disclose to any person any confidential information received in the course of the law clerk's duties. Because Bond was starting in May, earlier than her other clerk counterparts, she received no formal orientation at all. She knew that her judicial position, like others, were at will appointments that could be terminated with or without cause by the court, according to the handbook. At the time, the handbook did not make it clear that clerks had any right to seek confidential assistance or to file formal complaints if they were sexually harassed or abused by judges. Just after Bond finished reciting the oath and signed a form to confirm her acceptance, Kaczynski grabbed her arm. It's too late now, she said. He said, she can't escape any longer. She's my slave. Bond tried to make light of his declaration, suggesting the term indentured servant might be more appropriate for a one-year stint. No, I mean slave, he insisted. Bond was shocked by the term. Years later, when she looked back on that moment, she was offended for another reason. She knew there was absolutely no comparison between actual slavery and her federal clerkship, which paid well and opened up other opportunities. But as a young lawyer, she could not escape the powerful suggestion that Kaczynski had planted in her mind. For the next year, she would be his slave and follow his orders. So that's the kind of hold that some of the judges had on the employees, the people who had decided to come forward and blow the whistle, and then who many cases, in the cases I've looked at all over the country, not just the ones we've mentioned, but cases in Kansas, other cases in Washington, D.C., cases in Denver, other cases in California, many, many times when an employee came forward with a story like this, or a woman who had an encounter with a judge who was an employee, they were either ignored, their complaint was not investigated. In one case in Denver, the same judge who dismissed all of the complaints against Kavanaugh told the judge, after he heard that the judge had harassed someone, to go see a doctor. And then his plan was to dismiss the complaint as if going to see the doctor could cure sexual harassment, sexual misconduct. In my book, I was looking at those kind of things. I was looking at how did the courts respond to these complaints? What can we learn from that? And I was not making this up. I really followed a model that the courts themselves had used. In 2006, Justice Breyer led a group of judges who, along with staffers from the courts, reviewed the complaint system. They didn't look at sexual harassment, sexual misconduct, but they looked at complaints, the complaint process, and they found a lot of these same problems that I'm writing about in this book. And they also found that high-profile complaints, like the ones I'm writing about in this book, tended to be mishandled. They found that at least a third of them, around the third, had been mishandled by chief judges. And they told the courts the year before Cant's misconduct came to light that they needed to do better. And really, there's a lot of great recommendations that have been made by the Breyer Committee back years ago in 2006, by Law Clerks for Change, by groups like Fix the Court, and others, individuals, to improve this process, but to make it work there's got to be changes both to the law and that the courts have to commit to making it work. And, there's some people who think that if they don't, then the courts need an IG like everyone else has. But you've written recently that the IG system doesn't work that well either. So.
Well, unlike the courts, the IGs are to some extent marshaling some political power in Congress to achieve the power, it appears, to compel people who have left agencies to testify. But at least one of the things that really continues to disturb me about your book and your findings is that even though the judiciary has rewritten the code of conduct for these clerks to allow them to report, all of the cultural signs within the federal lifetime tenure judiciary seem to point to all of the downsides to reporting. You will be mistreated. You will be siphoned off. As Cathy McBroom was transferred to a different courthouse after she complained, Judge Cant got transferred to the same courthouse, and her family stood outside the courthouse and protested. Her family members protested, and nothing changed until later on in the story. But the culture that you write about here has not really bended in the face of some of these rather cosmetic changes.
I would agree with you. I mean, that's again why I think the book is important. I think that a lot of people don't realize how insidious this kind of misconduct is. A lot of times it begins with something that people joke about. When people make jokes about federal judges, what's the difference between a federal judge and God? Well, God doesn't think he's a federal judge, And, there's even a group of lawyers in Texas who have a really funny song about being appointed forever. Look it up on YouTube. It's quite funny. But fundamentally, this group of people who have what they call rabitis, people who are abusive in court, or people who do and say things that are beyond the pale, or even people who fail to report their conflicts of interest and believe that they're above rules like recusal. This is all abuse of power. And I think, what I'm trying to show in my book, that sometimes people who abuse power on the outside are doing worse things inside their courtrooms. And that, we need to take this more seriously. And absolutely, there needs to be a harder look, I think at these, at what went wrong in these cases and how we can fix it. And the courts have said, we are going to protect whistleblowers. But yes, I don't see how they are protected. And the office that they set up to supposedly help clerks, post the Heidi Bond's testimony, and because she also testified or provided information to Congress in the form of a letter, don't seem to work. In February 2020, we had very compelling testimony from a former law clerk who said, I called the person at that office because I spent a terrible year working for one of Judge Kaczynski's colleagues who was very angry about what had happened to Judge Kaczynski and knew I was a feminist, and began making misogynistic comments to her, remarked about, how he couldn't even imagine her husband making love to her because she was so ugly, things like that, really horrifying things. And she said, she told the members of the House Judiciary Committee she could not get any help from the courts. I thought that was really, really important testimony. And I think it remained unaddressed, partly because of the pandemic, but it remains incredibly relevant, incredibly important. There's, like I said, there's no shortage of great ideas of how to fix the system. The judiciary needs to do it. We shouldn't be okay with, what the Wall Street Journal has reported, and I think is also true in the sexual harassment arena, that many judges feel like the rules do not apply to them. There's a law saying judges need to disclose their gifts. Judge Kent didn't do it completely. That was one of the things he was investigated for. He didn't recuse himself from his best friend's cases. That was one of the early complaints against him. There's echoes of that in the Wall Street Journal articles that just came out this summer. And we see how widespread it is. The more these things are ignored, the more other people think it's okay to do it. So you have, over 100 judges doing these kinds of things. You have approximately 1,000 on the bench. But 1 out of every 10 thinks it's okay to violate the law on a routine basis. That's not acceptable. And I think that, 1 out of 3 high profile complaints being botched in 2006, and I'd say all of the federal judicial misconduct investigations of sexual harassment since then have been botched or not done one way or another since 2007, since Kent's case. And that's a serious problem that needs to be addressed. And that's the reason I wrote this book. I wasn't, just for fun. Although I think, the Cathy McBroom story is really a great story. And you talked, Carrie, about her family coming out. I think, when whistleblowers blow the whistle so many times, at the end of the day, they get nowhere. They get retaliated against, their careers end. Cathy certainly was retaliated against. She never really was able to become she was a case manager, but she never had the same kind of respect that she had before. She felt she was also put in a position where she felt that another judge sexually harassed her even after what had happened to her. And of course, she did not file a complaint that second time around because she had enough. She ended up retiring early from the court. But she does, at the end of the day, feel like she accomplished something. She made sure that this judge could not do the same thing to more people. He already done these kinds of things to many people, abused his power to abuse people. And she ended that. What she would like to see and is that her story told fully, which is obviously a very difficult thing for her, the kind of embarrassing details that are in my book about her, she is sharing with the goal of letting people inside this crazy world of the courts, inside the secret system that she had to deal with, so that you can know why it's important for that system to be fixed, whether you know anything about the courts or not.
Thank you so much for that. I'm going to open up to some audience questions now. We have some really good ones, including, speaking of the Wall Street Journal, from our friend James Grimaldi, who's a co-author on that very important series in the Wall Street Journal earlier this year about judges systematically violating laws and regulations about holding stocks. He says, congrats on a riveting book, albeit one I'm finding difficult to read because the behavior is so outrageous and unsettling. Isn't one of the problems that the only sanction for any violation, small, medium, or large, is extreme impeachment? James asks, what remedies do you think would improve investigations and potential sanctions against judges? And why do you think Congress has not already moved to pass reforms they've been discussing now for years?
Well, I think certainly, we run up against Article 3 of the Constitution, which says that the judges not only, they cannot be fired except through impeachment, but their pay can't even be reduced. And so you're right, James, that there's not a lot that Congress can do, but judges could be a lot stronger in, I think, the power of revealing what judges have done, sanctioning them publicly, reassigning them to less interesting duties. Those are all steps that the courts can take. Congress can strengthen the statute, that created this judicial conduct and disability procedure, to make it more transparent, to make it require more information to be shared. I mean, almost every other judicial disciplinary process all over the country is more open than the federal judicial disciplinary process. And I guess I would argue that I don't think that Congress should be so sparing about using impeachment when it comes to judges. If a judge does something that's a firing offense, there should be a committee that says, we're going to go ahead and fire up impeachment, because that should not be an empty thing. What's interesting to me is certainly when you get to the Supreme Court, there's even less, that we can do or say. There's nothing really that except impeachment. And, the Supreme Court doesn't even have a code of conduct. That's been something that's
honor.
And, the last person to ever the last president to get a Supreme Court justice impeached was Thomas Jefferson. Thomas Jefferson used impeachment against a Supreme Court justice he thought was abusing his power. And that, I think, was viewed by some historians as a mistake, as a breach of the balance of power. But I sometimes look back on it and think maybe that was a necessary step that he had to take to make sure that the courts knew that that was a real that was a real possibility, and that maybe, it's time for that to happen again.
Lise, before we get to another audience question, I just have a burning question for you, which is this. One of the reasons why the Judge Kent case was so unusual is because this man was actually criminally prosecuted by the Public Integrity Section of the Justice Department here in Washington. But as you describe in the book, that seemed like for a while, it might not happen. And it took a lot of pressure on prosecutors to make that case happen. What did you find there?
Well, that the story behind the scenes of that investigation is really interesting. I mean, because the Public Integrity Section has investigated multiple judges. There are other judges who were investigated at the same time as Kent, who were not prosecuted at all. And I think it was for political reasons. They probably should have been prosecuted. Kent, the lawyers involved in that case and the FBI agents, just like you were talking about with Larry Nassar, they really didn't know how to investigate a sexual harassment or sexual assault case. Those are usually handled by state courts, prosecutors. And Cathy McBroom had an attorney who helped her, who had been a state court prosecutor, and he basically investigated it for them and turned over a lot of the information. I was investigating it publicly in the newspaper. The two of us were putting a lot of pressure in one way or another. But they were looking harder at the conflict of interest questions, at lawyers who had taken Judge Kent to strip clubs, at lawyers who had given Judge Kent, trips, all kinds of things that really, those are laws on the books that judges are supposed to follow. And again, James and others at the Wall Street Journal proved that they're not following those laws. Kent certainly wasn't. But at the end of the day, there were no charges brought against Kent for those things. That part of the investigation did prompt another victim to come forward. Donna Wilkerson ended up coming forward in part because pressure had been put on a male law clerk of Judge Kent's who had been ensnared in that sort of world, Judge Kent's world of abusing and asking for favors from people. So that becomes part of the story. I'm not going to talk too much about that, but yeah, it was crazy. And at the end of the day, Judge Kent was not convicted of the sex crimes that he committed, even though he had to admit to them as part of a plea deal. He was convicted basically for lying to his federal judges in their secret investigation. That's what he was convicted for. That's what he went to prison for. And then even then, he did not resign. He tried to stay a judge, and he was only ousted because really James Sensenbrenner, who really did more than almost anybody during his years in Congress to be a watchdog of the federal courts, pushed along with other members of the House to have him impeached. And after being impeached, Kent finally resigned. But otherwise, I don't think he would have. I think he would have been happy to stay in prison and collect his pay.
Here's another audience question. There is legislation currently pending in Congress to create independent oversight of the judiciary and provide some independent review of complaints by employees of the judiciary. Do you have any thoughts on the likelihood of that getting through Congress?
Well, there are several initiatives. I mean, one is to basically apply the Title VII of the Civil Rights Act to the judiciary, which it's been on the table many times before. In the 90s, it was put forth as a possibility. It probably should happen. The judges should have to abide by the law that they, in fact, interpret in their decisions. There's not a lot going on right now with the Judicial Conduct and Disability Act reforms. There should be more, I think, happening. But each time these things come up, the judges push back and they say, well, balance of power. We need this power. We need our lifetime appointments. And they push back against it, especially push out very hard if anybody ever says there should be an IG, even though every other branch of the government has one. They don't want that. They want to have somebody like Judge Jones who can quietly and privately pick whoever she wants to investigate another judge as chief judge. And they want to have it so that if a chief judge in their 7 years as chief judge never wants to investigate anything, they don't have to. So I guess I just think I want more people to know about the system. I want you to know that, you can ask for the statistics about your circuit court. They're online, they're kind of buried on the website, but they're there. So you can see if the chief judge of your circuit doesn't ever investigate anything. And if they don't, ask them why. And the dismissal orders are posted on the internet. Nobody hardly ever reads them. I went through a lot of them for this book. Some of those are very serious complaints. Certainly, there's a lot of frivolous complaints from disgruntled litigants and from prisoners, and that's true. But a good 5 to 10% of all the complaints have something that should be looked at. And I think if more people paid attention to this secret system and asked for change, the judges would have to make more changes. But certainly, Congress, if they want to improve the system, they need to do their part too. Every time they try, it seems like the judiciary pushes back. So I don't know what the odds are. I think people who cover Congress would know better than me.
Another audience question, a little bit of a devil's advocate question. What's wrong with secrecy during the investigation of judges? Aren't criminal investigations usually done in secret until they're over or someone is charged?
Well, yes, but there's some big differences here. Big differences. First of all, the complaints are almost never made public, even if the facts in the complaints are proven. Now, sometimes complainants make them public, but the courts rarely do. The investigations of the complaints are almost never made public. There have been some exceptions when someone's impeached. The investigation of Judge Cant by the judiciary has never been made public. The complainant, even if they're deemed, as was the case in Cathy McBroom's situation, to be credible and to have a serious, potentially criminal allegation, they are not allowed to see the judge's secret response to their complaint. Cathy McBroom and her attorney were never able to read it or rebut it and see what kinds of things he had said about her. They had some idea of it based on the questions the judges asked her, but they didn't know what it was. When the Fifth Circuit Judicial Council voted on whether or not to discipline Kent, they were using the secret investigation that no one has seen. They were using testimony provided by people no one knows who they were. And except we do know Donna was asked for her statement and Cathy was asked for her statement, but we don't know who else really was testified. And they voted in private. They have never released any information about who voted how or what their deliberations included. And I don't think they ever will. There's another case that is just mentioned in the book. There's a couple other cases that I think are equally, they deserved more space. But I was also telling a story. I mean, there's a judge named Judge Nottingham, as chief judge in Colorado. 2 different investigative committees formed to investigate multiple complaints against him, made by all kinds of people, lawyers, journalists, others. Those investigations have never been disclosed. He resigned and they were just dropped. Nobody ever knows what was in them. Judge Walter Smith eventually was reprimanded right before he retired. But he was reprimanded for something he had done years before. He had forcibly, aggressively propositioned a court employee who then left. Her career was ruined. She asked the chief judge for help. He said, "What do you want me to do?" He never did anything. Years later, when a lawyer found out what had happened to her, he filed another complaint. That judge was reprimanded, but by then he could retire. He really had no consequences. He could leave, no problem. He kept his pay. So, I mean, this kind of pattern of things not being investigated has happened over and over.
I can definitely see how that would be waving the flag at the bull of the investigative reporter in you. Time is very short. So one last question for you. It's actually an important one. Do we know exactly how pervasive sexual misconduct is by federal judges? Is there really any way to tell?
Well, sure, there would be a way to tell. And in fact, law clerks for workplace accountability asked for the courts to do a national survey, confidential survey of current and former employees. The judges have refused to do this. There's no reason they couldn't do this. The Ninth Circuit, in fact, did something like this back in the 90s when there were a number of gender bias task forces in the early 90s, whose investigations and proposals were shut down largely for political reasons. And back then, they found that both misogynistic and sexual harassment kinds of behavior including remarks to lawyers about their appearance in court and all kinds of things involving employees, was common. I have no reason to believe it's not common today. I'm not saying that everybody does it. I'm saying that it's still tolerated. And since I wrote this book, I've had people pull me aside and say, you could write a sequel every bit as long and fill it with things just as appalling. And that makes me sad. But it also makes me think, we need to ask the judges to do more. We need to ask Congress to do more to address these things. And I hope that people read the book, not as a criticism so much as a lesson, that we could maybe all learn from, like why this does need to be addressed. We don't want to have other Judge Kents.
Thank you. Great moderating, Carrie and Lisa. There's so much to be outraged about in what you exposed. Let's hope your book does help spur the long overdue further reform of the system for holding federal judges accountable. To everyone watching, thanks for tuning in. A reminder that in the chat column, you can find a link for purchasing copies of Code of Silence. From all of us here at Politics and Prose, stay well and well.